Good morning, everyone, and welcome to the last morning blend of 2024. I'm Alison DiFlorio, and so honored once again to have my colleague from Fox Rothschild, Lori Armstrong Halber, as my co-pilot on this. Hi, Lori.
Hi, I'm always honored to be with you and with all of our friends who join us at these updates.
Yeah, I think this is, I don't know, 5 years and counting we've been doing this. And we always we look forward to every morning blend, but the year ends are always interesting. And this particular year end is interesting because of the election year. So we hope to spend the next hour with you sharing some HR and legal updates. Couple of housekeeping tips before we get started. As always, your questions matter to us, so please feel free to post them in the QA and we will do our best to address them. If we can't, our contact info is at the end of the deck here, and you can feel free to reach out to either one of us. We will be sending a recording of this presentation out post the session. So if you know someone who wasn't able to attend today, or if you hear something that you think would be relevant to someone you know, please share that with them. And your phones are muted, but again, feel free to post your questions. So with that, let's get into to our agenda for today. For those of you that have joined us before, welcome back. For those of you that perhaps are joining us for the first time, we always like to take a little bit just to let you know who we are, so you know where we're coming from and kind of the experience that we want to share with you today. I am, as I mentioned, Alison DiFlorio, co-founder and managing partner of Exude Human Capital. We're a boutique HR consulting firm headquartered in Philadelphia, but we support clients all over the country. We focus on providing HR outsourcing, both on an ongoing basis and also by project. We do a lot of work in the compensation space, which we'll talk a little bit about today. And we work with both in performance management, all of the traditional HR, both strategic and tactical pieces that you might encounter. We work with both the for-profit and the nonprofit space and have some government clients as well. So what I hope to share with you today are some of the trends that we are seeing and some of the ways that we've been and share a little bit about some of the ways we've been advising clients to address them. And I'll turn it over to Lori.
So nice to be here again, and welcome back to our previous attendees. For those of you who I've not met before, I have been practicing in the area of labor and employment law for, and now I get to say, almost 30 years. In my spare time, I corrupt young legal minds at Temple Law School as an adjunct professor, teaching employment discrimination law and a skills course actually on interviewing, counseling, drafting, for example. And I also serve as a volunteer mediator with the EEOC. A couple of years ago, I decided that I wanted to get a broader view than sort of, we always tend to look at things from the labor and employment lens. And so I got my MBA in 2019, right before the world shut down. I can't believe it will be 5 years
I know.
this March. That's amazing. But I practiced, exclusively in the area of labor and employment law. I should mention that Fox is a full service firm, and we provide services anywhere from, family law, trust and estates, to corporate litigation, mergers and acquisitions. I'm sure I'm missing great swaths of the type of thing, but we're, a 1,000 lawyer firm all over the country. But my clients range from very small employers to very large employers, both for-profit, nonprofit. And I really, really like what I do and love to work with folks and help them become, the best employers they can be. So with all of that, Alison, shall we talk about
Yeah, let's get into the
stuff?
program. So we've got some piping hot. I think on the last morning blend, we talked about FLSA being a done thing and nothing was going to happen. And well,
I was wrong.
we were wrong. Things can change. And then we'll talk about the NLRB. We'll talk a bit about what to expect with the new administration. And again, things can change. So we're just going to share what we see today and what we think you should be prepared for. And then from an HR perspective, we're going to focus on return to the office. And I know we talk about this quite a bit as well, but we do believe, and the trends are showing that in 2025, we're going to see a more concerted effort to get people back in the office. With that may come accommodation requests. So we'll talk about that. We're going to talk about the role of transparency in your organization and how important that is. So without further ado, Lori, why don't you get into some piping hot issues?
So if you were with us last time, the issues we're going to talk about are the FLSA ruling that came down on November 15th. And then also in November, the NLRB and what I will call their last gasp, I'm having a problem articulating today, came out with two more rulings that further restrict employers' ability to communicate with employees about union issues. So let's talk first about the FLSA ruling. When we last met, the July 1st deadline had already passed us. Most employers had already dealt with adjusting the salary thresholds. And I'm not going to go through what those are because apparently you didn't have to. I will say that previously, the federal court in Texas had enjoined the rule in Texas only. But by the time we spoke in the early fall, I think most people believed that because it took so long and because it had already been enacted, that the federal court was going to let it go. And if you may recall, what this is about are under the FLSA, the default is that employees should be paid overtime unless they fall into an exemption. And most of the exemptions fall under this white collar overtime exemption. And part of the criteria, it's not the only criteria, so I don't want people to think that salary necessarily means exempt, but part of the criteria is that these employees are paid a set amount, a salary, regardless of, and this is the term of art, the quality or quantity of the work they're performing. So every week they make the same amount of money, whether they work 30 hours or 70 hours. And the Department of Labor has historically raised the salary threshold. It happened during the Obama administration. You may recall there was some litigation and then they didn't raise it quite as high. But ultimately, the court allowed them to raise it, just not to the threshold that they wanted at the time. And it has happened prior to that as well, to adjust for basically for inflation and the what salaries are reflective. A 15,000 salary was a lot of money 40 years ago. Well, yeah, maybe 50 years ago at this point, and would not be anywhere near what we would expect to see for somebody paid on a salary basis. All of that said, the federal court in Texas, which is not surprising because most of the federal legislation that gets challenged and overturned comes out of Texas, set aside this final rule that had been issued by the Department of Labor in its entirety. So the rule had said that there should be an increase in the salary threshold effective July 1st, another one effective January 1st, and then there was an escalator provision which increased the salary threshold every 3 years. My clients were not happy about having to adjust, but it wasn't quite the fire drill that we saw during the Obama administration. And most folks sort of adjusted to this concept. And I think most folks that I deal with recognize that there should be some adjustment over time to whatever that salary threshold is. Not that everybody likes it, but they sort of get the policy reason behind it. Well, as you may recall, in our last conversation, we spoke about a case called Loper Bright, which overturned another decision by the Supreme Court called Chevron. And I'm not going to get into all the minutiae, but I said at that point, this might be creating problems because it really undermines the authority of the federal agencies. And despite that Congress usually creates those agencies, at the same time it creates the statute that those agencies, we would have said, are charged to interpret and enforce. The Supreme Court has held in that Loper Bright decision that agencies don't actually have the right to interpret. It's really up to the courts. And so we have seen a lot of federal legislation and regulation over the past several months be undermined or vacated or set aside by the federal court. And that is what happened here. So what does that mean for you? Well, you have an employee relations issue if you try to sort of backtrack what you've already done in July, but you technically could. I wouldn't probably recommend it because if you're not in a field that you can expect a union to knock on your door immediately or have a lot of attrition, or, there's just a lot. I don't know of anybody who's doing that. Let me just say that.
I
Uh,
second that. I don't know anyone who's rolling back.
yeah. But you don't have to comply with the increase in January or the escalator provisions in 2028 or thereafter. So, mea culpa, my mistake. But this is a lesson, because I think we're going to see a lot of things that we don't expect over the next 4 years. And when we get to talking about that, I think that that's going to be a theme. Okay. Also in November, on the 8th, and I think it was the 15th, or no, I'm sorry, the 13th, the National Labor Relations Board issued two decisions. And I just want to remind everybody that the National Labor Relations Act covers both unionized and non-unionized workforces. Now, some of this is going to apply more if you're either already unionized or being unionized, but don't ignore it just because you think, well, we're not union, we don't have to think about it. These decisions are, I would say, the culmination, or as I said, the last gasp of the current administration's attempt to really encourage union organizing efforts and be, as President Biden had said when he came into office, the most pro-union administration in the history of the United States. And the first case is a case called Siren Retail Corp. You would know it as Starbucks. But in that case, the National Labor Relations Board determined that employers could violate the National Labor Relations Act by making statements during a union campaign regarding the consequences of a unionization on the employee-employer relationships. What does that mean? So typically when a workforce wants to be unionized, or a union comes in and solicits the workforce to be unionized, they go through this process. They have to have at least a third of the workforce demonstrate an interest. That's called a showing of interest. And then after that, they can petition the National Labor Relations Board for an election so that the employees can vote on whether or not they want to have a union. Or if they have a showing of interest by more than 50% of the workforce, they can ask the employer, it's called a demand for recognition, to voluntarily recognize the union as the exclusive bargaining representative for the employees. There are some employers, particularly nonprofits or who have a progressive philosophy, who will agree to voluntarily recognize. But most employers decide they want an election, mostly because they think all of the employees should have a say in, or an opportunity to vote and decide whether or not they want to be unionized. And without an election, there's a possibility that some of the workers don't have that say. But I give you that background because this case really deals with the kinds of communications employers can have with employees while there is a union petition pending. And employers have long been restricted from threatening employees, if you go union, we're going to close, or making promises. If you don't vote for the union, we'll give everybody a raise, from interrogating employees. I think we've talked about that before. While your inclination might be, oh my gosh, you think you need a union. Why? What's wrong? What can I do to fix it? You're actually prohibited from doing that. So employers have generally taken an educational tact. I know my union friends would say, no, you're union bashing. I'm going to say that it's an educational tact where they explain what it means to be in a unionized work setting, because oftentimes employees don't know. It is true that a union and employer have to sit down and bargain over things like wages and benefits and other terms and conditions of employment, but there's more to being in a unionized workforce than just that. And the employer often wants to express their view on what that means. And so employers have long said, it will interfere with our direct relationship, or that having a union here will have a negative impact on our direct relationship. And the National Labor Relations Board believes that those statements are coercive and violate the act. And so now employers can't say that anymore. I will say that I think that you're going to see a swing under the new board, but for the time being, if you find yourself either you have union activity going on, you have a petition filed, or someone has said, we want you to recognize our union, please contact your labor council. And I mean labor council, not employment council, somebody who operates in this space. There are a few of us like me who do both, but it's really has its own scheme and its own rules, and it's very different. If you don't have anybody, you are welcome to call me. And if I can't help you, I will connect you with one of my colleagues, whether at my firm or another firm. The other decision that came down similarly restricts employer speech. So if we go to the next slide, this case is actually an Amazon case. And as you know, Starbucks and Amazon have been huge in the papers and in media regarding the different union organizing tactics. And the interesting thing is, although Amazon got a lot of attention, it's only a couple of places where there has been any, we'll call it success at organizing. In any event, again, usually during a union campaign, employers will hold or would have held what we call mandatory meetings, where the employer says, listen, you're on the clock. We want you to come to this meeting. We're going to pay you, and we want to give you our view on unions. And the general counsel, Jennifer Abruzzo, or at least for the next month, has long held that she felt that those were coercive because the employees don't have the right to decide whether or not they want to attend the meeting. They are compelled to do so. The board generally, or at least this board and the general counsel generally believe that the employer-employee relationship are inherently coercive anyway. And so captive audience meetings have been in their sights for some time. Well, on November 13th, in this Amazon.com Services LLC case, the board said you cannot have mandatory meetings anymore. Captive audience meetings are prohibited under the act. They are coercive. They violate the employee's rights to engage in protected concerted activity or not. You can have meetings under this, quote, safe harbor provision, where in advance of the meeting, you articulate that you're going to express your views on unionization at the meeting. The attendance at the meeting is voluntary. You're not subject to discipline, discharge, or other consequences for not attending the meeting, and we're not going to keep records of who attends or leaves the meeting. Both of these cases, I think, are subject to challenges on First Amendment grounds, because this is the government restricting private employers' right to speech. And so that we've not heard the last of these. I'm making no predictions whatsoever, other than to say the next administration is on the opposite side of the pendulum as this administration, for the most part, when it comes to traditional labor. And so I don't expect these cases to stand, but I will tell you that over time, when we see pendulum swinging, we usually, on the average, end up somewhere in the middle. So there may be some sort of, there's probably going to be an undoing of these, but ultimately we might settle somewhere with some sort of guidance regarding the types of statements that employers can make or not. I would argue that employers are already restricted, and these are an overstep. And I argue that from my professor hat, not just from my management side labor lawyer hat. So those are the piping hot things that have occurred within the past month. And that probably brings us, to
Before
a
we
nice
move
segue.
forward, I just want to make a little plug here for a future in-person workshop that Lori and myself and another colleague of ours, Melissa Weiler Gerber, will be conducting, just to help kind of educate people on this whole kind of the NLRB decisions, and just to give employers a space to ask questions. So that's coming. We also did a podcast on, hold on, let me close my door, that was released, I believe, either in September or October, that I think you might find interesting as well. So if you haven't taken a listen to that, it's one executive director's experience working really closely through the collective bargaining process. And I think it's got some really great tips on how to make it an effective process if you're in that experience. So just a couple of tips to think about. Daily brew. Okay. So this is the big question that everybody is asking. What to expect with the new administration. Lori, I'm going to ask you to kick that one off, and then we're going to move into some of the things that we're seeing on the HR side so that you can get ready.
Sure.
You should put the caveat on the front end. Everything we're about to talk to you about is probably subject to change in some way, shape, or form, but this is what we know to be true today.
Okay, I see a question about the 2024 independent contractor rule. That really wasn't on the agenda today, but if I can squeeze it in, I'm happy to talk about it. And if you have a specific question and I don't get to it today, let's make time. I'm happy to talk to you about it afterwards. The changes, let's start with the NLRB because, we just sort of talked about those cases. So when President Biden took office, one of the first things he did was to fire the then general counsel of the National Labor Relations Board, who had been appointed by President Trump. The current general counsel, Jennifer Abruzzo, she's not going to be surprised. The question is when. I don't know whether it'll be on President Trump's first day, but she's going to be looking for work. And additionally, the board is comprised of 5 members, and the party that holds the House, the party that holds the White House holds the majority of seats on the board. So for most of actually, I might say for all of the Biden administration, we've actually had a vacant seat. So there have been 3 Democrat appointed members of the board and 1 Republican. His name is Marvin Kaplan. And so we will expect that Member Kaplan will be elected chair. I believe that the current chair, Lauren McFerrin, could roll off. The question is whether or not you don't need to know all this. All you need to know is we're going to see a shift and we're going to see probably rolling back a lot of the initiatives and case law that was made, but it takes time. So, for example, there is a current case that came down during the Trump administration that deals with whether or not you have to bargain over discipline before there's a union contract. It's technical, but the reason I mention it is that case was never overturned during the entire Biden administration. I mean, I guess technically it could be overturned. Usually we get a flurry of cases at the end of December, but as of today, that case still remains in effect. So although we expect a far more employer-friendly board, and it might change your strategy if you're dealing with union organizing, one, I would not expect there to be a decrease in union organizing efforts. And in fact, we might see an increase as workers feel that their rights are threatened based on other changes that the Trump administration might make regarding employee protections in the workplace. So it doesn't mean that, oh, great, we won't talk about unions anymore. But it does mean that some of the broader interpretations and broader prohibitions and enforcement of what I would call pro-union law is likely going to be curtailed under the Trump administration. The Department of Labor, which is the agency, it's got a broader scope than you might expect, clearly wage and hour, but also child labor, and also OSHA falls under the Department of Labor, so safety protections. President-elect Trump has campaigned on not taxing tips. He's actually stated that he's amenable, and we won't know whether any of this is actually going to happen, but at least during the campaign, he said he was amenable to an increase in the minimum wage to $15. I will see. But you can expect rollbacks on protections for child labor, protections for safety and other health and welfare issues, protections even under benefit plans that might be covered under ERISA, 401k protections, because the administration's general philosophy is deregulation. And so where the Obama administration, the Biden administration have used these agencies to uh, enforce and protect, or protect and enforce um, things that affect workers in the workplace, expanding, for example, the Pregnancy Fairness Workers Protection Act, which I butchered the name, but you know what I mean. You know, those types of protections came under Democratic administrations. You should not expect to see those. All of that said, it's very interesting. His nominee for labor secretary is a woman out of Oregon who lost her congressional race. And she, interestingly, is one of the 3 Republicans who voted in favor of the PRO Act, which is actually it is a I would call it a pro-union organizing act. Now, I want to make clear the Department of Labor isn't involved in labor management relations in that sense. That falls under the NLRB, but it's sort of an interesting pick given her, support of what would have been a pro-union agenda. So, I mean, his statement is that her name is Lori. She spells it right. Great. But President-elect Trump has said her strong support from both the business and labor communities will ensure that the Labor Department can unite Americans of all backgrounds behind our agenda for unprecedented national success, blah, 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 blah. The head of the Teamsters also said that North America's strongest union is ready to work with you every step of the way to expand good union jobs and rebuild our nation's middle class. Now, I know that some of this is politics and people are positioning themselves, but it's just a very interesting pick. She has to go through the vetting process and the confirmation process, so we'll see. But as I said, she was in favor of the Protecting the Right to Organize Act that would have allowed more workers to organize and would have penalized companies for violating worker rights. So, this is kind of an interesting pick. So I have a whole lot of, I don't know about this, but I thought it was important that we talk about it. Immigration, you should fully expect to see crackdowns on immigrants in the workplace. And yes, I did not write undocumented workers or illegal immigrants or unlawful anything. You're going to see you should expect to see increased enforcement actions, raids, I-9 audits, all of those things. And just by way of history, all of those things, the Immigration Reform and Control Act was passed in the 80s by a Republican president. And in that act, that created I-9. And the idea behind it was to fix the problem of undocumented immigrants in the US. So a lot of those were given amnesty, and in exchange, basically require employers to police illegal or unlawful undocumented workers by having them comply with these I-9 requirements. So, it's no secret that the Trump administration has made very clear that immigration is, at the top of their list. So if you haven't done it in a while, you should do an I-9 audit. You can do it with an HR consultant, that's fine. If you call counsel, you have the opportunity to keep some of that information privileged and protected from disclosure. So if you're working with outside counsel, I would suggest you consider doing it with them. Again, I can help you, or I can connect you with someone if it's not me, but you should really make sure that your stuff is in order, because we expect to see a flurry of activity in this area. And lastly, and I won't spend a lot of time onto it, I named the 2 individuals that are, at the front of appointments. One is Andrew Lucas as an appointment with the EEOC. He would be the new commissioner. And then Stephen Miller, Trump has said he wants to appoint him as deputy chief of policy. And that will have an impact because both of them have publicly stated a lack of support, that would be the nice way of saying it, for LGBTQ initiatives, and various other, they're very anti-affirmative action. We've already had a ruling by the Supreme Court in the Harvard case restricting affirmative action, but DE and I initiatives are going to be under further attack, and it's going to be a little complicated balancing your obligations not to discriminate against folks with, I think most employers are understand that having diversity in the workforce makes you a stronger employer. So you're going to have some challenges navigating these areas. Alison and her team are very well equipped on the DE and I front, and I can certainly help, or you should consult with your regular labor and employment counsel on any sort of discrimination, disparate treatment. If you have an employee who's saying, I don't feel like I'm being treated fairly, don't ignore it, because this is going to be a really interesting area. And the last thing I would say is we might see, I don't like this phrase, but we might see what some people call a spike in reverse discrimination claims. So I think both Lucas and Miller have said that they believe that white men are disadvantaged under current policies, and so you may see challenges there that you're going to have to contend with. So what to expect with the new administration? Generally, deregulation. I think some confusion, and we're going to have to kind of wait and see which initiatives. The administration does have the advantage of having a Senate majority. That said, I don't know that some of the old school, traditional, conservative Republicans are going to rubber stamp everything that President Trump seems to want to do. So that's where we are.
Yeah, and I would just add to that last piece around the EEOC and the DEI. I think the employers we work with really focus on creating cultures of equity and inclusion, right? And that doesn't change. That continues. So I think continuing the work that you're doing to create the kind of culture that you're trying to drive will continue. But to Lori's point, you may hear some people or just a lot of stories or news about some different thinking around diversity in the workplace. Other things to be thinking about, and I want to pull up the context that Lori created, kind of where we may be going into 2025 with people considering third-party organizations, unionization, et cetera. These three areas are a big impact to how people think about the cultures of their organization. Return to the office, accommodations, and transparency. So returning to the office, and I know we've talked about this time and time again, but what we have seen, even in the Philadelphia area with new mayor requiring city employees to come back to the office, and I'm not quite sure, Lori, where they stand on that. I know there was some pushback from or some litigation there. But what I can say is nationally, and this is interesting, Los Angeles and Boston have shown the largest return to the office across the country. And in California, there was a mandate for state workers to return on a hybrid basis. And once that happened, you started to see other employers following suit. Now, when I say return to the office, that doesn't necessarily mean 5 days a week. What we are seeing that's holding pretty consistently since people started bringing people back to the office since the pandemic is that 3-2, 3 in the office, 2 at home, or a 2-3. But the 3-2, 3 in the office, 2 at home seems to be where about 69% of the workforce is expected to be in 2025. Right now, that's at about 62%, but it did increase from 23 to 24, and they are expecting it to go up to just under 70% in 2025. Regardless of what you choose to do in 2025, whether you're going to remain hybrid, remote, or you're going to pull back to the office, it's what we're seeing, and where we're seeing engagement issues is when whatever you decide to do is not effectively executed across the organization, right? Now, we do know that in some types of industries, there are positions that can work effectively remotely, where others are very direct client care and have to physically do their job in the office. Where it gets tricky is when you're in an organization where you have multiple areas that could effectively do their work in a hybrid or remote setting. And some department heads are holding people accountable to being back in the office and others are not. So our recommendation for you is to, whatever it is you decide, that's what you need to run your business, but make sure that you are consistent about how you are executing that across the organization so that people are clear. Leaders, if you are expecting your people to be back in the office, you should be in the office too. You know, it doesn't, what you have to lead by example and help people make that transition. The other thing, and many of you probably know this, if you are returning people to work, whether it's hybrid or full-time, give them that window to be able to make the arrangements that they need to make to be able to come back to the office. So whether that's childcare, pet care, anything, elder care, anything they may need to situate, you know, if you don't want to say, hey, next week we're going to be back in the office, give them that 30-day window or so to get their affairs in order. Um, and make sure that you have your managers, and Lori and I, that's like a broken record, but train your managers to be effective in managing in whatever structure you decide to have. So whether it is back face-to-face conversations, do they have the good communication skills to engage with people? Are they good at giving and receiving feedback? If they're working in the hybrid or remote, are they effective at connecting with people and making them feel included and like they belong if they're not seeing them every day? We know from experience that it can be a little tricky to keep people who are working out of the office feeling engaged and included when those in the office have more face time with a manager. So just make sure that you're supporting both the employees and the managers in effectively making that transition. The
Let
other,
me
go
let
ahead.
me just answer your question. If you're talking about there was a union challenge to the Philadelphia mandate, and the court denied their challenge and their request for an injunction in the summer. I do not know what has happened since then, but I don't believe that. I believe it's going forward, but although with a lot of resistance. And so before you start talking about accommodations, I would say, if you're making a decision about whether you want people in the office or not, check your own bias about why you want them in the office, because there are a lot of people who believe, who have preconceived ideas about whether people are in the office or out of the office, and younger workers in particular are super frustrated with these, what they would call old school notions of control, and they're much more task oriented and much more why do you care when and where I get stuff done? And I'm using generalizations, than older workers. And so I think it's important that employers make the right decision. Certainly there are some businesses that they have to be in the office, like it's a no-brainer. And there are people who abuse working from home, and you have to deal with those things. But I see some clients sort of making a default because they think it's easier, and now they're losing talent. And so I just wanted to jump in and make sure that you're really thoughtful about the decision, and check your biases to make sure that, like if I can't work from home, therefore nobody else can, is not probably the soundest reason to make that decision. And it might be that having people in the office is better because of the type of business that you do, or because you want people face to face and brainstorming, and all of those things are fine. Just make sure you're making whatever decision you make for the right reasons, because this will lead right into what Alison's about to talk about. Accommodations come when you start making mandates to things that people have been able, when you start mandating things that people have not had to do in the past.
Right. And you said something that I just want to underscore there is, performance matters regardless of which of these structures you have. So you have to hold people accountable. Some people don't do well working remotely. It's just not it doesn't have the structure that perhaps other people are more comfortable in. But regardless, that could happen in an office as well. So make sure that your performance management processes are in place. And again, your managers can manage effectively. The other thing I wanted to just mention here too, one of the benefits that we have seen, and the data supports this, is that even giving people 1 day a week to work from home has a significant positive impact on rates of burnout. And there's something about just knowing that there's that 1 day or 2 days that they're not spending however many hours commuting back and forth that gives them a little bit more peace. So those are things to keep in mind as you make your decisions going into 2025. So accommodations, what we have seen since the pandemic, and we anticipate seeing more of as businesses make different decisions about their structure, is request for accommodations to either remain working remotely or to minimize perhaps the number of days. Lori, I don't know what you have seen, but from where we sit as HR people, we have seen accommodations around anxiety and stress with regard to things like driving, because people spent a lot of time during the pandemic not driving. Um, we have to be mindful that each individual has to be treated as an individual case, and your
Can't say that enough.
and your internal process should be clear that you follow the law, which is engage in that interactive dialogue, that your managers are aware of the triggers to listen for. So it's not always necessarily just saying, Lori, I want an accommodation. It can come in different ways. So it's important that they are educated and prepared to either tap human resources or whomever they need to engage with them in that conversation with an employee to discuss an accommodation. And then it's up to the employer to determine if it causes an undue hardship to the business. And I think that kind of goes to where Lori's saying is, what are you doing? Is there a bias that is impacting your decision to return someone to the office or to make this accommodation or not? Or is it really a business decision? Is it impactful to the business and could create an undue hardship to the business? You've heard, pre-pandemic, we've talked about somebody who needs a certain chair for their desk. And, that's it's not a big expense, unlikely to cause an undue hardship. Somebody not able to drive for a role that requires driving as a primary function of the job, that may be different if that work cannot be done remotely and have an effective impact.
Yep.
So make sure you have your process in place, that your managers know what to do, who to go to, as the HR professionals in your organization can guide you through that. But you just want to refresh people's understanding of accommodations. Lori, do you want to add anything to that?
I mean, you're right on the money. And one of the things that we're kind of waiting to see how it shakes out is the analysis of, if you were able to accommodate them working from home, is that reasonable now? Because there's a tension in the law. Something you said is really important. The employer gets to make business decisions. And so there are certainly cases where the employer has said, I want everybody back in the office. And that's a business decision the employer gets to make. The question then becomes whether or not allowing someone to work from home is a reasonable accommodation. And again, the employer has the opportunity to explore other reasonable accommodations that might allow the employee to continue working and mediate whatever the impairment is that's interfering with their ability to work. And so it's a little bit complicated. Again, these are the kinds of areas, you should be working with an HR professional and probably with counsel in determining whether a request to work from home is going to be reasonable accommodation. The only other thing that I would say is that undue hardship under the ADA is an extremely high threshold. So, the good news is you don't have to pick the employee's choice of accommodation. You have to provide a reasonable accommodation. But if there is no other accommodation and it's not an undue hardship, then that might be considered to be reasonable to allow someone to work from home, at least on some sort of basis. So it's a very, and the last thing that you said is super important, is that it is all on a case by case basis. The ADA, the Supreme Court, and Congress have both repeatedly said that it requires an individualized assessment. So you can't have a black and white rule when it comes to accommodation, which, as we know, creates issues then because other employees say, well, if they can do this, how come I can't?
Exactly. Exactly. So the other piece we want to talk about is this age of transparency. And we are seeing in study after study, engagement survey after engagement survey, the request for transparency is popping up as one of the top 5 drivers of employee engagement. And typically we hear transparency around pay. That's where it first appeared, and we'll talk a little bit about that. We do a lot of work in that space, and it doesn't necessarily mean that every organization should be publishing their salaries and all information about that. It's really about transparency in the process, how pay decisions are made, how frequently you're going to evaluate market data, et cetera, having a good compensation philosophy. But we're now seeing, and this comes into people thinking that they feel included in an organization or their voice matters in an organization, better communication around organizational changes. And what I mean by that is, it's not just boom, the leader pulls everybody together and says, this is what's happening. It's giving the why behind it to the extent that you can. It's giving a fuller picture. And this does not mean that you're disclosing everything that happens behind a closed door, but it does mean giving enough information so a reasonable person can understand why the decision was made. They don't have to agree with it, but that has a tremendous impact on the levels of trust. You see the stat to the right there. In a recent report, 86%, I think it was either McKinsey or Deloitte, 86% of leaders agree that the greater the level of transparency, the higher the level of trust. And for all of you in business on the phone right now, you know that trust equates to a healthy organization. It is foundational. Without that, nothing else really is going to impact how somebody feels about the organization. And interestingly, you see that stat about employers that are planning to take action. And 80% of employees want better understanding of how decisions are made. Again, it's not necessarily that they need to have the decision to be decided in the manner that they want. They want to understand the process that is used, what considerations were taken place to the extent that you can. So I'm going to call it the age of why, and it's explaining a little bit more of the why, which we tend not to do, generally speaking. The other big piece around transparency is career pathing, and this has been a trend over the last couple of years, but will continue to be a very strong trend in 2025. Job seekers and employees want to know what their path is. And for smaller organizations, that may not be a direct path of climbing. It might be a path across, expanding skill sets, expanding exposure. But to be able to articulate what someone's potential or how somebody's path, what their path could look like, is really critically important to today's workforce and the workforce in 2025. The good news is that, we do see that there's a business impact to transparency. We see a 21% increase in profits, much higher, 76% higher employee engagement. And this is interesting, just about a 30% higher employee satisfaction with their lives. As you've heard us talk on many of our webinars in the past, the lines between work and life are really blended now. So if something's happening in life and it's not acknowledged in the workplace, it can be very difficult for that employee to be productive and focused. So if we know that the more transparency, the less mind space somebody has to be thinking about, well, why did they make that decision? The more people can focus on the work that you want them to do. All of these things are important to an employee's decision as to whether they feel included and part of a workforce, that that their voice matters. And this is important for those of you who are, want to continue to drive your culture. I wanted to share this, and I'm happy to talk with people about this afterwards. This is just something that we created to help the employers we're working with on compensation as they think about pay transparency, because it's a continuum. Not everybody's going to be on the same place in the continuum. But if you think about this in helping leaders decide where they want to be, what does transparency, what is it going to mean in your organization? All the way to the left, no transparency. It's big mystery. Nobody knows how pay decisions are made. To all the way to the right, where things are posted and everybody sees. By the way, we don't have any clients that are all the way to the right. We have quite a few clients that are falling in that, or strive to fall in that moderate transparency. And what this does is give clarity to your leadership team on thinking about what does transparency mean in our organization. So when employees are asking questions, you can say with confidence what you are going to be able to share with them. So I'm not going to go over all of this. I just wanted to share this as an example of a tool that we created to help people define what transparency means. All of you as a takeaway should think about that as a leadership team. What does transparency mean in your organization across the spectrum, not just with pay, but with other employee communications and business decisions? Things you can do immediately. Hey, think about providing employees with a clear development path. Again, this doesn't necessarily mean, you do this and then you move to this step and this step, but it gives clarity about the steps people can take to enhance their knowledge and perhaps grow their pay at your organization over time. Ensure alignment of your business goals and objectives. Make sure that people know that the work they do is contributing to something that has a business impact. And then the communicate effectively. Boy, is this going to be the year of communication. I remember someone once saying to me, look, what I tell you today may change tomorrow, but you have to trust me to know that if it changes, I'm going to let you know that it changed and I'll communicate that to you. So it all goes back to that foundation of trust and strong, effective communication processes. The other thing too that's very important is to be able to give and receive feedback. This is going to be a time when asking employees periodically, I'm not talking once a year or twice a year, but in your regular check-ins with them, hey, what's working well? What could be better? And be willing to receive that and listen to it. Doesn't necessarily mean you're going to agree with it, but to listen to that feedback so you can share same and create more of a culture of ongoing feedback. So you don't let issues fester and become problems. You actually address them real time rather than waiting just to do a survey or something like that. Lori, do you want to add anything to anything that I've shared?
I mean, I can't say enough. I use this example when I'm doing leadership training about if you're sitting on the runway and nobody says anything, that time on the runway feels insufferable. And even if the pilot just comes on to say, I'm not quite sure why we're here, I'll let you know as soon as I have more information, it brings everybody's anxiety, at least it lowers it a bit, right? And somebody made a comment in the chat, and I agree with this, that there's an irony in people feeling like, well, why can't I work wherever I want or do whatever I want as long as I'm getting it done? And then we're in this age of why, and they kind of go together to me, right? People, and maybe in generations past it was like, shut up and pay your dues, and that was sort of, and we all did. We're like, all right, we'll shut up, we'll pay our dues, right? At least Gen Xers were sort of like, I think, a little bit of a rule follower in that regard, maybe. But folks want to make an immediate contribution and they want to understand why they're doing what they're doing. And I said to you, this is just as an aside, a commentary, I'm very curious to see how some of the big companies that were sort of getting a lot of press for everybody wants to work there that are now imposing, kind of restrictive, everybody has to come back to work all the time, we don't care kind of thing, or imposing rules and publicly saying, well, we don't care, we hope people quit. Like what the long-term impact of those decisions is going to be on those organizations, whether or not they'll survive or have to adjust. It's curious.
Yeah, and we know historically pendulums swing and swing, so we'll see what this means. But I'd strap on your seatbelts because it's going to be an interesting year coming up.
If we have a minute, Allison, and I don't want to, if you're not done, then keep talking, but
No,
I
no.
can adjust, I can address the independent contractor question if you have a minute, if we have a minute left.
Yeah, go
Okay.
ahead.
So there was a question earlier about the 2024 independent contractor rule and what employers should consider for compliance. So the rule came down earlier in the year, and there's been this back and forth between, there was a 2021 rule, and then there was a 2024 rule, and the 2024 rule came out. The 2021 rule, and I'm saying this and you're going to be like, I don't really understand. It's okay, bear with me. The 2021 rule had only 5 factors and eliminated this quote investment in work idea. It had designated 2 factors, opportunity for profit or loss and control over the work, as these core factors. And a lot of us sort of like that because it makes it feel like they're really running their own business. And that's sort of the way we think about an independent contractor. But the Department of Labor thought that the rule was inadequate for a couple of reasons. And I won't get into all that because we don't have that much time left. So they reinstituted a rule with 6 factors, and that came down, and we covered that, I think, last session, the session before. Mm-hmm. There are legal challenges to that rule as well. And as I said earlier, because Chevron was overturned by this case, Loper Bright, it's likely that that's going to affect the independent contractor rule, because courts are no longer automatically required to follow or give deference to the Department of Labor's rule. So I don't have an answer as to which rule you should apply. I also think that classifying people as a worker versus an independent contractor is a little bit like, if it walks like a duck, it talks like a duck, rather than whatever you label it. The Department of Labor, no matter who's in power, does not care what you label something. They're going to look at the relationship between the parties. You should also know that the Department of Labor's default, again, regardless of party, is that employees or workers are employees, not independent contractors. The policy behind that is that we want to protect workers by making sure they get paid at least minimum wage, they're eligible for overtime, et cetera, et cetera. So, I really look at, this is blasphemy, I know. I sort of don't care what the rule says because it's going to be subject to some court's interpretation anyway. And when I work with clients, we look at things like, how are they being paid? Is it work that is the essence of the company's work, or is it ancillary? Are you hiring somebody to do a project, or are you hiring temporary workers to do the same thing and work along side by side with your existing workforce? The more whatever these people are doing are more like the type of work that your folks are doing, and that they are treated more like your other employees are treated, the fact that you call them an independent contractor won't protect you. I am happy to send over the 2 rules. I'm happy to talk to anybody about those rules if they have questions about them. But it's really a very fact-intensive analysis. And to me, whatever the test is, the biggest thing that courts look at are control. How much control are you exerting over the day-to-day and the details of what these folks are doing? The more control you exert, the more likely they are to be employees. And lastly, so that Alison can take us back to the end with a closeout here with some tips, understand that different states have their own rules. California has a very different rule that definitely skews towards employee and away from independent contractor in most circumstances. That's called the ABC test. So if you have workers in multiple jurisdictions, it's not just whatever the Department of Labor has said, you also have to be in compliance with those jurisdictions.
Great. Thank you for that, Lori. And
Yep.
just to wrap up, this session, just remember your return to office, have your policies, your communication strategies in place, train those managers on how to be effective in whatever work structure you decide. Brush up on accommodations and just make sure you have your process in place and that you are engaging with your internal HR, or certainly reach out to legal counsel or your HR consulting person to help with that. Continue to train, as things change. You've got to spend time developing supervisors and managers on what they need to know to be effective and to feel confident, and lead by example. That's just particularly as it relates to the return to the office. And on that note, Lori and I just want to thank you for another year of taking time out of your day to spend time with us. We hope you have a wonderful, safe, peaceful holiday season. And we will be back first quarter of next year for 2025 series of morning
Wow.
events. So thank you, Lori, for your continued partnership. We so
Thank you,
appreciate it.
Allison. And thank your team, by the way, because they always are the ones that get us together.
Yeah,
Whitney
Whitney
and
is in the
folks.
background, and
Yeah.
I'm always sending her things at the 11th hour for this session. So thank you, Whitney, for being there to support us. So happy holidays, everybody. We look
Thank you all. Happy holidays.
in 2025.